Morning.
Good morning. May it please the court, I'm Judy Levinson, representing the appellant Anthony Bott. Mr. Bott formerly practiced law in Massachusetts, but resigned in 2005 as a disciplinary measure. He has since requested permission to work as a mediator in Massachusetts, as any non-lawyer can do. However, the Bar Council has denied his request. Therefore, he has requested by means of a petition to the court for permission or authorization to work as a mediator in Massachusetts. His petition should be allowed for several reasons, which are set forth in our brief. First, Mr. Bott, his proposed activities working as a mediator do not constitute the practice of law, as Bar Council concedes in her brief. Moreover, Mr. Bott has acknowledged that he will disclose in writing in advance of any mediation that he doesn't represent any party to the mediation and moreover will not be providing legal advice. Second, Mr. Bott never worked as a mediator in connection with his former law practice. Therefore, he would not be committing any type of unauthorized legal work, even under the terms of that expanded definition by Bar Council, which does not have any support or prior precedent.
Well, let you finish your list.
Was there another on your list?
Third, and perhaps most significantly, prohibiting Mr. Bott from being allowed to work as a mediator would essentially expand the scope of his bar discipline to prohibit him from working in an area outside the practice of law without providing any type of standards, guidelines, or authority to individuals as to what the basis for such discipline would be. And the consequences of doing that are particularly serious in situations such as this one, where the penalty for violating the terms of his probation or the terms of the court order accepting his affidavit of resignation could be some type of criminal sanction or a criminal prosecution. So essentially, Bar Counsel's position is that while the proposed work of mediating is not the practice of law, his activities are so close to the line of practicing law that they should be prohibited. However, there are no standards or guidelines to say what that is. That would raise a series of very troublesome, potentially troublesome scenarios. For example, could Bar Counsel potentially prohibit a disbarred lawyer from being employed as a newspaper reporter or a radio commentator to comment on issues of the law? Or could a disbarred lawyer be prohibited from being employed as someone writing a blog about law issues? Or
this may be a question of semantics, but would Mr. Bott be mediating matters that are legal?
Mr. Bott would be mediating a variety of issues, but he would be serving as a facilitator. He would not be in any way making determinations about legal rights or responsibilities.
Might he be mediating legal rights?
He would be serving as a facilitator concerning issues that might involve legal rights, but he would not be in any way determining or establishing those rights. He would be acting simply as a facilitator. And the distinction, he would not in any way be determining issues of legal rights and responsibilities. Rather, he would be facilitating a voluntary and confidential process between willing parties to explore whether or not they might voluntarily enter into a settlement.
Can I ask you this?
I understand the request, and I'm wondering whether you think that since it's actually come to this court, the court could, in this case or more generally, impose limitations on the scope of mediation, the type of mediation, the conditions under which somebody in Mr. Bott's position could mediate? Or is it your view that since it isn't the practice of law, it would be as impermissible as if the court were to say that a disbarred lawyer couldn't be a securities trader or something like that?
The rules as currently written do not provide any authority for Bar Counsel to provide any discipline beyond the sanctions that are set forth in the rules, which so far have applied to the practice of law. If the court makes a determination, it seems it would be based on some broader authority, but the question at that point becomes what the authority is to limit someone's prospective employment outside the practice of law as a discipline for a Bar Counsel violation, for a disciplinary rule violation.
Well, I take it this goes to the same point. You're here because, probably out of an abundance of caution, you wanted to go through a process seeking approval.
Correct.
So you went to Bar Counsel and you're here, rather than just having your client go out and set up a business and then maybe it works out, maybe it doesn't, maybe there's some further enforcement action. But if we agree with you, I take it, and all of these sort of limitations that you're talking about suggest that we might have some role in the future in these kinds of requests. But is your position that if that we should decide the case in your favor, and therefore this is simply outside the realm of our regulation for disbarred and suspended lawyers?
Well, I believe as the situation currently exists, there is no authority for preventing Mr. Bott from engaging, or any other disbarred lawyer from engaging.
So that's your position. If we agree with you that he can engage in this, then we essentially are saying we have no jurisdiction over that.
Well, if the court were to promulgate in the future some sort of rules with respect to either the
Suspended or disbarred lawyers. And we're talking
That is
about, the
correct.
only reason we have jurisdiction
Yes.
is that this person is a suspended or disbarred lawyer.
That is correct.
But in this case, given that the petition is before the court, are you saying that it's an all or nothing proposition, or even on this petition, is it your view that the court might say yes, but within these parameters?
Well, I don't believe under this situation that there are any parameters, because I don't believe any authority is set forth in the disciplinary rules or otherwise, nor has there been any notice or guidance as to why these activities would be prohibited. I think it's, as we've set forth in the brief, clear based on the rules as they currently exist, that mediation does not constitute the practice of law. There has been no notice as to why or how somebody who might be approaching a line that is too close to the practice of law would be passing over that line. And absent some sort of standards or guidelines, this court will be drawn into, it seems, constant line drawing on a slippery slope. So therefore, perhaps if there are standards or guidelines developed in the future that will give guidance to disbarred and suspended lawyers, that might result in a situation of certain guidelines or standards that apply to disbarred and suspended lawyers versus others. But at this point, there is nothing in the rules that support this type of discipline that essentially would say, Mr.
Not discipline. I mean, it's, right?
Well, it would be essentially an expanded discipline beyond the scope of that provided. He would be prevented from undertaking employment that does not constitute the practice of law.
Or legal work? I mean,
Or legal work, that is correct.
You treat those as synonyms. Is
I
that
don't.
correct?
Bar Counsel has taken the position that legal work is a concept that is broader than the practice of law. That concept, first of all, none of the court's cases have supported that distinction. Every case that has been decided in this area has referred to the practice of law. Even the SJC county court cases that Bar Council relies on do not use that term legal work. But putting aside that distinction, more significantly, the three cases that she does rely on all stand for a different proposition. Namely, those were situations in which disbarred lawyers all happened to practice in the real estate area prior to their disbarment, subsequent to disbarment in various shapes and forms. They proceeded to undertake certain types of work that could have been conducted by lawyers, but they had also done so in their prior real estate practices. So I believe the point is that the risk of public confusion was high in that situation where one attorney was directly...
So you are saying, well, so if a lawyer has, in the lawyer's practice, regularly mediated and put himself or herself out there as a mediator, then we could regulate that post-suspension or post-disbarment. But if they haven't, we can't?
Based on the Suffolk County Court cases that Bar Council is relying on, I believe that Mr. Bott's situation is distinguishable from those for the reason that he did not practice as a mediator prior to becoming disbarred.
But should we sort of try to evaluate, or should Bar Council try to evaluate how much of someone's practice involved mediations in determining whether or not there's jurisdiction to approve or disapprove mediation?
Well, there are no guidelines now about that issue, but certainly on the facts of this case, it's not even a question because Mr. Bott did not engage in any type of mediation or work as a mediator prior to his disbarment.
But why is the question whether he engaged in mediation as compared to what he did for substantive work that he now seeks to mediate? So, for example, I understand that many mediators are not lawyers, but many mediators are lawyers, and they practice as both, but not for the same people. So, for example, what if the practice, Mr. Bott's practice, had been divorce, and he now seeks to be a divorce mediator? Would that be okay, even though he's never mediated before?
The issue is that, for example, the rule governing lawyers specifically says they have to make certain disclosures, and the ethical rules relating to mediators say that they cannot provide legal advice or act.
They cannot provide legal advice or representation, and you make those disclosures to the individual. But if you're a divorce practitioner and you're then mediating, you bring with you the information, your experience, your training into the room when you facilitate an agreement that doesn't necessarily have to adhere strictly to the legal parameters, and that's why you have mediation, so you can go outside them if they want to.
But if the mediator is not acting as a lawyer, rather he's demonstrating the skills of a mediator rather than a lawyer, the issue is whether as a sanction, how far can he be walled off from his entire life experience or education and life experience in terms of trying to obtain subsequent employment outside the practice of law. Now, the court may determine that there are some limitations, but right now there is no guidance to anybody as to what those might be. And
but we're not really preventing him from doing anything in terms of work, I don't think. It seems to me what we can do is make a determination that even though, or even if, mediation is not the practice of law, it is so close to the practice of law in our interest and our responsibility in regulating the practice of law and seeing that the public perception of how we regulate the practice of law and the honor with which people conduct their practice of law is so critical in this case that we don't think it's appropriate for him to practice mediation. Now, he may snub his nose at us and go out and practice mediation. We may not be able to prevent him from doing that, but what we can do on a petition from Bar Council is say, you've done this in violation of our ruling, and if you seek to return to the practice of law you will be prohibited from doing that for a period of time beyond that which would normally flow from your either suspension or disbarment. If a lawyer were suspended or disbarred because of gross inattention to the client and gross incompetence, wouldn't that warrant us in saying that, no, he should not be a mediator?
That is a determination the court could make. It would seem unnecessarily harsh under these circumstances where Mr. Bott is subject to 10 years of continuing probation. He certainly will not flaunt anything the court says. He's here because he takes seriously these limitations, because he is trying to rehabilitate, because he's trying to pay more by way of restitution, and he is trying to find his way back into a way where he can pay back to society and pay back his debts. The court may make that determination under these circumstances, and with no notice it would seem unnecessarily harsh. He would be subject to ongoing monitoring through the system. He can be monitored through mediators who have to constantly evaluate his credentialing, his qualifications, and his effectiveness.
Counsel, your time is up.
Thank you.
Good morning. I'm Dorothy Anderson, Assistant Bar Counsel. The problem, of course, that is faced by the court and by Bar Counsel in these kinds of cases is that disbarred lawyers and suspended lawyers frequently try to get re-involved in the profession by means of some activity which is very closely related to what they did before, although not necessarily the practice of law. And the court, the county court, of course, has confronted this several times in the cases that we cited, the Oates case, the Shanahan case, et cetera. And the court has, the justices have consistently said, just because a non-lawyer can engage in a certain activity without practicing law.
But this is really different, isn't it? I mean, in the sense that, yes, it's a lot of lawyers mediate, but by definition, mediation requires the lawyer to not be representing anybody.
Well,
so it is a different role than one plays in virtually all lawyer activities in which, you know, it's a representative capacity that one is serving as a lawyer.
well, if the only, you know, salient part of the definition of the practice of law was representing a client, I believe you would be correct. But that is not the only, and again, this is legal work. This is not the practice of law. And representing a client is not necessary to being engaged in legal work. I mean, I think this court has talked about lawyers who have been abstracting titles or have one lawyer wanted to volunteer to work for the Registry of Deeds, I believe, to, you know, aid people who came in asking questions. So the fact that the mediator is not representing one of the parties to the mediation does not in and of itself mean that the lawyer is not engaging in legal work.
How is it legal? I mean, social workers, psychologists, whole hosts of individuals with no legal training at all do mediation.
That's true, Your Honor.
And then is it only legal work because a lawyer is doing it? What makes it legal work?
Well, again, the county court cases that I've cited say even though a non-lawyer could do it doesn't mean a disbarred lawyer can do it. The questions that those cases present, or the tests, are, one, is it something that's closely related to the practice of law and also closely related in the minds of the public to the practice of law?
So what was it about his case that we should look at in deciding whether or not he should be allowed to proceed with mediation?
Well, I don't think we're suggesting that it's something special about his case, Your Honor.
But if it's not something special about his case, then you're asking us categorically in all cases to say that mediation is not something that's available.
Mediation of legal disputes. Now, there might be some disputes which are not legal, which might be family disputes or disputes among children in the playground.
Everything is legal. I mean, any dispute has a legal potential because somebody can bring a lawsuit about
I
it.
don't know that that's true. I mean, you could have situations where a family is trying to decide which sibling and what kind of a schedule siblings should take care of elderly parents, or whether they should go to the in-laws or the parents for Thanksgiving or Christmas. There are disputes that are not legal disputes, that do not involve legal rights. But the things that Mr. Bott proposes to mediate are, and he sets it out in his affidavit, landlord-tenant, consumer issues, insurance issues, employment issues, a couple of others, all of which clearly are the subject of Massachusetts statutes, regulations, and case law. And it would be hard to imagine that Mr. Bott could be involved in mediating those disputes without relying on his legal experience, his knowledge of those laws, his knowledge of the courts. How is this situation going to
Actually,
play?
I thought the mediation training had less to do with law than in figuring out what individuals with different interests want and how you can bring those disparate interests to resolution, notwithstanding that they could go to.
I think that, first of all, as I understand it, Mr. Bott has 32 hours of mediation training as opposed to 20 years of legal training and experience. In a perfect, I think there are some mediation idealists who say this is purely a matter of bringing the parties together. But we know that all these lawyers out there are mediators.
But Ms. Anderson, lots of things. Take mediation out of the picture. Lots of professions. I mean, once one is a lawyer with 20 years experience, one is going to use that experience in whatever one is doing. So if one became, as I said before, a securities trader or something else that even you couldn't say was the practice of law or legal work, clearly that person is going to be using his or her legal training and is going to be using his experience and training in performing whatever that function is. I think it's, I don't know how you divorce that from the person and say, no, you can't do anything in which your mind is going to be thinking like a lawyer. I mean, using your background as a lawyer.
Again, here, we're not just talking about thinking like a lawyer, although I think I mentioned that in my brief.
did.
Maybe that's overstretching a little bit, but certainly knowledge of the law. That's what all these kind of disputes that Mr. Bott wants to mediate involve, knowledge of the law, telling people what's going to happen if they are not able to resolve the case and go to court.
If we don't agree with you, but if we do agree that we should consider the nature of his transgressions as a lawyer, what could you point to in his particular circumstances that would lead us to conclude, or should lead us to conclude, that he would not be appropriate, it would not be appropriate for him to serve as a mediator, other than the fact that he was a lawyer?
Well, Mr. Bott, as you know, not only voluntarily resigned as a disciplinary sanction for his conduct, which was intentional conversion of client funds, but also was indicted and convicted of many counts of grand larceny, did time in prison, and is now on probation. We don't know a lot about Mr. Bott, frankly, and this is another point I'd like to bring up. If Mr. Bott was here saying that he would like to work as a paralegal, there would be a whole supervisory structure put into place. Under the statute, after 7 years, he could seek permission to work as a paralegal, and many lawyers do that. And in that case, the single justices have generally said, okay, but we want you to be working under the supervision of an attorney in good standing. We want that attorney to know that the nature of your misconduct, why you've been disbarred. We want the attorney to inform us if you don't work, if you stop working for him and go out on your own. And also, we want you to perhaps fill out some portions of the reinstatement questionnaire in which you have to tell us, what have you been doing for the last few years? Have you been working? Have you been paying your taxes? Why haven't you been making restitution as ordered? We don't even know why Mr. Bott got involved in stealing all this money 7 years ago. We have no idea.
Let me ask you this. Are we the first state to deal with this issue, or have other states looked at it?
Could not find anything else, Your Honor, except that the state of Carolina has specifically passed a rule saying that disbarred and suspended attorneys cannot mediate
South Carolina, right?
South Carolina, yeah.
Now, what is the authority of the BBO to prevent somebody from doing something for which they do not need a license? When you've taken away their license, and it's appropriate to say you can't do anything that this license allows you to do, but you're saying we want you to, we want to be able to say we take away your license and now you cannot do things which you would be able to do without a license.
Well, we're operating under Rule 4.01, Section 17.7, which says disbarred or suspended lawyers shall not engage in legal or paralegal work. I mean, that's already in the
Okay, is it your
in the
contention that what
rule.
he's doing is paralegal work?
Well, I think it's comparable to paralegal work in the sense that it's work very closely related to the practice of law, but it is not the practice of law.
But do you not define paralegal as working under the supervision of an attorney?
It generally is, yes, but I don't know
is
if
it ever
it's
not?
exclusively. You know, I don't think the term paralegal is very well defined either, and it covers...
Which are you resting on here? Are you saying that what he's doing is legal work or paralegal work?
Legal work.
I would say it's legal work, Your Honor.
Okay, so you're not claiming it's paralegal
I'm not
work.
claiming it's parallel, but I'm using that as an analogy, that if you wanted to, the question was, why do we have the authority to tell him that he can't do something that isn't the practice of law? And what I was saying is, well, it's right there in the rule that he cannot go back and become a paralegal without seeking permission of the court.
And going back to Justice Spina's question to your sister, let's assume somebody just does it. What is the bar? What is the BBO to do?
I think he suggested the answer, or somebody did, which is that there really isn't much we can do. I mean, if he was in violation of the order issued by the court, his suspension order, then conceivably he could be held in contempt. I don't think that's the case here, having looked at the order.
What does the order say in that regard?
The order, it's in the appendix. It's not. It says he should, give up his license, be stricken from the list of attorneys, and that he should resign from his cases, close his ALTA accounts, et cetera.
But there's also the special condition of probation that he not hold himself out to others as an attorney. Mm-hmm. And I'm a little puzzled as to what it is that what we're being asked to do has to do with the special condition of probation, if anything.
Nothing from our point of view, Your Honor. I mean, we're certainly not here to enforce the special orders of probation.
But aren't you suggesting that what this work as a mediator would be legal work, and by extension, legal work may be holding himself out as an attorney? And would he not be risking, based on the position that you take, would he not be risking the special condition of probation?
I don't think we would suggest that he'd be holding himself out as an attorney. And again, we don't take a position about whether or not he'd be violating the probation
So
order.
if he's not in violation of the order, and he's not in violation of any special condition of probation,
He'd be in
where comes your
violation.
authority?
First of all, he came and said he wanted to work as a mediator. Would Bar Counsel agree to that? And we said no, and we didn't have we don't have any authority to tell him not to. We could only say that if he went to the court seeking permission, as he intended to do, that we would oppose it, and we did oppose it. And we opposed it on the grounds that he's engaging in legal work. And if he comes back to seek reinstatement, then the question would be, was he in violation of any of the rules while he was practicing, and is something that a hearing panel could take into consideration.
And if he, instead of filing this petition, had decided he was going to set up shop as a mediator, I take it that Bar Counsel would have filed a petition here that he be asking that he be held in contempt.
No, I don't think that we would have.
You would have.
I said I don't think that we would have.
You would not have.
I
He would
no,
have
Your
just
Honor.
waited until
It's
he
not a
sought
clear
reinstatement?
order. There's no clear order
Yeah.
issued by the court that says he cannot engage in legal work. So I don't think we would have been in any position to seek contempt. But had he come back to ask to be reinstated to the bar, we would have asked him what he had been doing. And when we found out that he had been mediating legal disputes, we would probably ask him more questions about it and then probably oppose his reinstatement.
But let me just get back to one other hypothetical that we had been talking about before. If somebody who was not a lawyer, had never been a lawyer, and committed the crimes of manslaughter, rape, pillage, and plunder, and was just paroled, that person could set up shop as a mediator.
As far as I know, Your Honor, certainly we would not have any jurisdiction over them, and I don't think anybody would. I mean, mediators are not licensed in Massachusetts, and I also want to, point that out, because unlike some of these other professions that lawyers often have a co-membership in, like being a licensed real estate agent or being a licensed CPA, et cetera, a mediator isn't licensed. All they have is some training and maybe a piece of paper from some kind of a program saying that they've undergone this training. But most mediators practice by virtue of their knowledge, experience in some other discipline, and of course many are lawyers. And if all those lawyers out there who are practicing mediation in their firms could just continue to do that, then of course anytime a mediating lawyer was disbarred, we would face the issue of, can they just continue to mediate in their same office with their same mediation clients? Would they even have to inform those clients that they had been suspended or disbarred? So the problem is that lawyers are mediators. There's rules about it in the Massachusetts Rules of Professional Conduct. There's court rules about mediation. It is so closely aligned with the practice of law that would create a huge number of confusing issues were suspended or disbarred lawyers be permitted to mediate legal disputes.
Thank you very much.
Thank you.